Okay, so today I want to talk about Article 41 and 42 because these are very important articles in the economic part, the economic relationships, and quite a significant difference to the English style. So in Article 41, it starts like this. L'iniziativa economica privata è libera. That means the economic initiative is to open a business or start an activity that's economic, like open a shop or a factory, or maybe expand a factory, maybe change a factory from producing boots to producing trousers or whatever. This is an economic initiative and it's free. It's not controlled from authority, from the government. This is really to ensure that we do have a free market, that the government isn't in control of everything. Remember, in the time they wrote this constitution, there was the philosophy of the communists versus the capitalists, and the communists didn't believe in economic initiative. It was the government's role to do any economic activity, and then people lost their freedoms, because if you control all economic activity, you control more or less all our lives. What we consume and what jobs we do and where we live, and it's really linked to our freedom. So that was quite important, that l'iniziativa economica privata è libera. Non può svolgersi in contrasto con l'utilità sociale o in modo di recare danno alla sicurezza, alla libertà, alla dignità umana. So here we're being couched in the collective. So it's not the private interest is not elevated over the collective interest. The collective interest always is supreme. So this initiative can't go against the social benefits and damage security and freedom. So security may be, we're talking about buying guns or maybe health. We can talk about health in terms of cigarettes or dignità umana, drugs or prostitution. These activities mustn't happen with this initiative. These activities need some control because they're not. And then it says la legge determina I programmi e I controlli opportuni perché l'attività economica pubblica e privata possa essere indirizzata e coordinata a fini sociali. So here we're saying it must always go towards social purposes, ends. So it's that collective interest is very, very important. So here we have this economic relationship, which normally the liberals are very concerned with. It's part of their values that you can develop economically without too much interference from the authorities and a big state. Etc. You need. They like the economic rights. But here it is couched with solidarity and social rights, and this solidarity, this last part, is a form of solidarity, which we can find in Article 2. Solidarità è inderogabile. So it's rooted in there. And also in Article 3, which talks about the state removing obstacles which impede the development of the individuals. So, in that way, all the private initiative must also be towards this aim, this social ends. So we can see a very strong value on the collective interest, even when we talk about the economic relations. This is very different in England. In England, we've got the idea that the individual interest is supreme. You know, Adam Smith, the father of economics, said individual ambition serves the common good. So always the individual interest must be elevated. So they must be free to be able to do what they like, never mind about the collective interest. For the English, the collective, it will always be in the collective interest, the individual interest. So we are a little bit different. We do want economic initiative to be much more uncontrolled and without considering the collective interest, because we think that will happen anyway. We're much more of the idea that it's a natural process. It doesn't need any laws to state that it must happen. So that there is a little bit of a difference in Article 41 from the English mentality, or the United Kingdom British mentality. This article itself did actually come to have some problems with the European Union philosophy, because the European Union needs that any economic activity is not protected. There is a free market. If the Italians protect Fiat and the Germans protect Vauxhall, then it's not really a free market. It's which state is more powerful in protecting their interests. The European Union didn't want this, and so there are rules that say, we have this free market and unfair competition is illegal. And this was put to the test with Italy, because Italy did have some rules which enforced this Article 41 to say that the consumer and the worker must be considered. And there was the case of Costa versus Enel in European Court of Justice, where a lawyer argued that Enel must consider not the European laws of free, fair competition, but the national interest. What the Italian worker and the Italian consumer must be the highest interest. Never mind, being free and competitive, etc. And the European Court of Justice did say, no, that's not the legal position. The legal position is European law is supreme. So this article, the roots of the Italian laws which enforced this article were considered not applicable. The European law had to be applied of fair competition, and that was a demonstration. So this is a kind of interpreted in a different way now. The governments can't, ensure it's always for social purposes, but the economic activity must be free from help and protection, and must compete. And we see in the result of this, fiat without protection after many years has become stronger and stronger, more and more innovative, better quality, etc., etc. And companies like Fiat have really developed and improved. So this article originally was interpreted in a different way. Now, the supreme law is the European law, and that's how it should be. Remember, the European law is reciprocal. It is what we've agreed to in treaties, that we agree to limit our sovereignty if that's what is decided in the European Parliament, and we accept European law, and all that is written in the treaty, agreed in the treaties. This is international law, and in Article 10 it says Italia conforme al diritto internazionale. Also says in Article 11 that we limit our sovereignty for the purposes of being part of an organisation that has peace at its is for the purpose of peace. So we have agreed to obey, make the laws supreme for us. And then Article 42 says la proprietà è pubblica o privata. I beni economici appartengono allo Stato, ad enti o a privati. So this means that we've got public and private property. That again is trying to ensure that we do have a mixed economy. The means of production can be owned by the privates. Remember again, the Soviet, the communist philosophy was all property was public, whereas in the past, a long time in America, a long time back before the Depression, Great Depression, all property was private. Now it's saying property can be public or private, and so it's establishing this mixed economy. And it says la proprietà privata è riconosciuta e garantita dalla legge, che ne determina i modi di acquisto, di godimento e limiti allo scopo di assicurarne le funzioni sociali e di renderla accessibile a tutti. Now, this is very significant. It says the private property is recognised and guaranteed by the law. In the Statuto Albertino, private property was inviolable. It was a fundamental right. It was part of our human nature. Here, it's only recognised and guaranteed by the law, so it's not really seen as so fundamental to us. We're not. It's not really. It's the law that decides whether we can have a private property or not. It's not part of our deepest, most natural rights pre-state. So that's a big difference. And again, in England, we do have this feeling that it's more inviolable. Just thinking of the laws in Italy, usus scopione, where after 20 years, if I tend agricultural land for 20 years, it becomes mine. Or if I got, that's immobile, but something mobile, like somebody lends me something, a computer, after 10 years, it's mine, if I take care of it, etc. So there is this idea that private property isn't so attached to our most fundamental human nature. It's not part of us. There is, you know, the laws. There are laws where, you know, private property can be confiscated if it's not being used for social means, if it's just left untended and the local authority thinks that it could employ people or could be producing something for the community, they could take it. This, you know, unless it's for a motorway or something in England, they take it if your house is built where they want to build a motorway. But private property is a bit more sacrosanct. Just like in the Statuto Albertino. Remember, these are in England. They are, and they was in times of Albertino monarchies where you have landowners, and it's very important for the landowners that this land is kind of part of them, kind of feudal thing. So we do have a different relationship. And then it says, la proprietà privata può essere nei casi preveduti dalla legge salvo indennizzo espropriato per motivi di interesse generale. So this is talking about if they want to build, I don't know, a tunnel or a road, and your property is there, they can take it for the general interest. That's the same in the UK. And then it continues, la legge stabilisce le norme ed i limiti della successione legittima e testamentaria ed i diritti dello Stato sulla eredità. Here, I think they had in mind the royal family, the royals, and whether they can come and claim all their castles in Italy or not. You know, so they're stating it's the law that decides this, not some ancient birthright because you were from royal blood. Okay, so they're establishing that really clearly, that it's not hereditary, it's the law that decides what can be inherited and what can't. And obviously the Italian royal family couldn't inherit their castles and properties from the pre-war period. That was established by the law.